I'll start by just stating that the U.S. holds a deep commitment to the rule of law and constitutional protections of personal rights, including privacy. Laws in the United States are adopted in specific contexts to address specific issues. We have a sectoral approach to address these specific risks, which have largely resulted from moments, and not always the best moments, in U.S. history. This historical context is very important for understanding the U.S. privacy regime. For example, the United States Privacy Act of 1974 restricts the United States government's activities to protect our democracy. It was enacted after the Nixon administration targeted over 8,000 people who it considered its political enemies, violating the First Amendment of our Constitution for tax audits. Another example is the Foreign Intelligence Surveillance Act, FISA. It was enacted because the FBI was using its power to conduct electronic surveillance for national security purposes to target Martin Luther King Jr.'s First Amendment protected activities. And these are some examples where laws were then adopted to address specific risks after lengthy public debate with general consensus about risks and how to mitigate them. This typically results in buy-in from the public and buy-in, or at least a clear understanding of the requirements from industry. We believe this approach to privacy results in very high compliance rates, laws are enforced, and we say what we do. We do what we say we do. In the US, each agency is required by law to have a senior agency official for privacy. I think that's something that not everyone knows about the federal government, and those are the principal advisors to leadership within each agency on matters pertaining to personal data. So I will start by providing an example of that, which is at the Department of Justice. The Chief Privacy and Civil Liberties Officer, with my office's support, the Office of Privacy and Civil Liberties, is responsible for protecting privacy and civil liberties through review, oversight, and coordination of DOJ's privacy operations. We have a lot of different functions. We provide advice and guidance to over 42 components at the Department of Justice. For example, the FBI, the Drug Enforcement Administration, Civil Division, Criminal Division, many, many more. We ensure compliance and conduct compliance reviews of proposed and existing programs, so privacy impact assessments. We also develop and provide privacy training for all personnel, at least annually. I will tell you, it is oftentimes weekly with our teams. We develop privacy policy, we prepare reports to Congress and the President, we review information handling practices of the department to ensure practices are consistent with protection of privacy and civil liberties. We advise the Attorney General about balancing the need to protect privacy and civil liberties while considering proposals that retain or enhance government powers. We also investigate and respond to privacy and civil liberties, complaints, incidents, and that includes data breaches. Under DOJ policy, we also maintain senior component officials for privacy within each of the 42 components at the department. So for example, at the FBI, the National Security Division, and we coordinate with, train, and oversee these component officers, as well as work with their teams that are embedded in their components' operations. We work directly with IT, the Chief Information Officers, and offices to understand and embed privacy controls into systems, processes, understand the actual uses of data, map data flows, understand interconnections between systems, as well as conduct annual audits. So that is a very brief primer. I could go on for a very good amount of time about all of our different functions, as well as many, many, many more laws that apply to the federal government. But I will now turn to the Data Privacy Framework and the Data Protection Review Court. So transatlantic data flows are critical to enabling the 7.1 trillion EU-US economic relationship. The EU-US Data Privacy Framework, which I'll refer to as the DPF, will restore an important legal basis for transatlantic data flows by addressing concerns that the Court of Justice raised in striking down the previous EU-US Privacy Shield framework as a valid transfer mechanism under EU law. So the executive order bolsters an already rigorous array of privacy and civil liberties safeguards for US signals intelligence activities. The prior examples of statutes that I mentioned, the Privacy Act of 1974, as well as FISA, apply to these activities. It also creates an independent and binding mechanism enabling individuals in qualifying states and regional economic integration organizations as designated under the executive order to seek redress if they believe their personal data was collected through US signals intelligence in a manner that violated applicable US law. The The new framework and the regulation that was issued by my office establish enhanced privacy safeguards for data collection and use, greater oversight, a new redress mechanism, the Data Protection Review Court, and transparency. In December, the Office of Director of National Intelligence issued Intelligence Community Directive 126, procedures to implement the new framework as required under the executive order. Various IC elements, intelligence community elements, will adopt their own internal procedures to then ensure implementation of the executive order. And these are just a handful of the items that we have been very busy over the past 6 months trying to implement to ensure that we are meeting our obligations under the executive order as well as under the framework with the EU.